Start. Sir, I shall deal with the question straightway. So far as permanent or temporary workers are concerned, the provision specifies the period of service, and it has been further defined that many days of service constitute continuous service for a year. About what action will be taken against the employer if he fails to implement the provisions of the law has made provision. Compensation is a legal obligation and it can be enforced. Sir, I have not to add very much to what I said at the outset. I find that the reactions to the proposed legislation proceed from two different and opposite angles, and if I may submit, the two extreme views put forward are based on some kind of misunderstanding or imperfection. Understanding of the aims of this legislation and the ends which are sought to be achieved through their limited aims. They are twofold aims. Firstly, coming to the views expressed by my honorable friend Dr. Mukherjee, the question was viewed chiefly from the interests of the industry, and from the other side, the question was viewed chiefly from the interests of workers. We have tried to balance both these things, but no claim is being made that through this legislation all that can be claimed on behalf of the industry or on behalf of the workers is going to be achieved, because the two aims are fair deal to the workers, and that production should not be curtailed, and also that the industry should not suffer. Now, this legislation also has two aspects. One is the attempt to prevent closures through the deterrent effect of these provisions. That the is a good deal of substance in this approach will be evident from the fact that in the first case, when an ordinance was promulgated, a number of closures which had threatened actual did not materialize. This means that sometimes the closures were not really so very necessary, and that there were no compelling reasons. There may be some consideration of avoidance of a little loss is time when there is depression, when one can do without additional production and things like. Then the limited interest of a particular individual employer and not the larger national interests concerning production or the interest of the employees may perhaps be the consideration. In these cases, this legislation has a salutary effect. It will still have that effect when we pass this law now. But if either the workers or those who are very keen to have no curtailment of production think that this is going to stop closure, it is not so. Other things have to be done in order to prevent closures which are preventable. Some suggestions have been made by my honorable friend here. They are very good suggestions, but they do not directly concern us here. We have to do other things. We have got the Industries Development and Regulation Act, and we can put into use the various provisions of that act also. Something of that kind was done before in the case of one concern to which my honorable friend there made a reference. I may inform the House that even in the case of the closures which have occurred and regarding which we received information, we started acting. I believe that some inquiries are in progress, and it is quite possible that where this legislation which we are going to pass may not come to our rescue, something else may possibly be done. There are suggestions like standardization of wages, decasualization, etc., and there will be the other suggestions also. Why is it that a management, because of its inefficiency, because of neglect, allows the concern to run down to that condition that it ceases to have its competitive position in industry? Various things can be considered, but this is not the place for that. Similarly, so far as employees are concerned, something is being done on their behalf. First, if the legislation succeeds in preventing a closure, to that extent unemployment is warded off. To the extent it does not succeed, some relief is afforded to the workers. They get some compensation, but that does not exhaust all that the workers may be able to secure from industry. At the time of termination of their service, there may be provisions for gratuity, etc. They are not ruled out, they are not eliminated, By these provisions, therefore, the scope of this legislation does not cover fully either the ground of continued production and of averting unemployment, or in the case of unemployment, of what is going to be done for the employees. So, sir, in that limited context, we have to view the propriety of the various clauses that are being considered here. Regarding some specific points made, it was urged that if we have brought this bill at the fag end of the session and therefore we are not giving enough time for consideration, that is a question which depends upon the convenience of the House. This honorable House is aware of the policy with regard to coal that has been embodied in the second 5-year plan. The target of coal production at a figure of 60 million tons per annum has to be attained at the end of the second 5-year plan. That means an increase of 22 million to over the existing production of roughly 38 million tons. Of these additional 22 million tons, 1 million tons of additional coal production will be in the public sector and 10 million tons in the private sector. To attain this target in the public sector, the government has established a National Coal Development Corporation. The functions of this corporation are to work those collieries which at the moment are under state control, and also to develop new collieries so that this additional target of 22 million tons may be attained in the second 5-year plan. When the coal position was examined, it was found that all the important area where from coal could be exploited were covered either by prospecting leases or by mining leases. In order that the government might be able to produce additional coal in the public sector, it is necessary that we should have the power to acquire rights with regard to those areas of land where coal is likely to be found. This bill therefore gives the necessary authority for the acquisition of rights which will confer upon the state ultimately. When the various proceedings which are mentioned in this bill are taken, the right to exploit coal and develop those coal fields, the pattern upon which this bill has been framed is a pattern with which the Honorable House is familiar. The broad pattern with regard to the procedure follows the pattern down in the Land Acquisition Act. There are two stages at which different notifications issued. I draw the attention of the Honorable House in this connection of sections 4 and 7. Under section 4, it is giving notice of government's intention to prospect for coal. After the issue of that notification, authority is taken for entering upon and surveying any land in such a locality, to dig or bore into the subsoil, to do all other act necessary to prospect for coal in the land, and to undertake all such other steps which can be described as exploratory in character. Sir, after this information is collected, preliminary work is done, and if the central government is satisfied that the coal is obtainable, then within a period of 2 years from the date of issue of the notification under section 4, it will give notice of its intention to acquire the whole or any part of the land, or of any rights in or over such land as the case may be. It would be necessary because otherwise government would have had on its hands areas which need not have enough quantities of coal, or coal which could not be economically prospected. Then after the issue of this notification, other things follow. The usual type of steps are visualized in order to enable the government to effectively get hold of that land and to undertake prospecting. The other clause about which I would like to make a mention that at this stage is the clause relating to payment of compensation. There may be criticism, sir, with regard to the principles which have been enunciated for assessment of compensation. These principles are given in clause 13 of the bill. The criticism may be of two kinds. My friends opposite may criticize it on the ground that the principles that have been laid down are too liberal and are weighted in favor of those whose rights are to be acquired. Then again, sir, there may be criticism from some other friends, maybe, sir, towards my right or to the left of my honorable friend opposite, who might be able to put up a case saying that we are making a departure from the normal principles with regard to which the country has become familiar, namely those under the Land Acquisition Act, with all the provisions regarding the payment of solatium of 15% or the like. Government, sir, in this particular case have adopted a pattern, some indication of which had already been given by Parliament. I would in this connection, with your permission, Mr. Vice Chairman, like to refer to the principles which are laid down for payment of compensation under the Mining Leases Modification of Terms Rules 1956. These rules, sir, were discussed there in a parliament and these rules were later on adopted. I won't weary the Honorable House by reading the various clauses of the relevant rules. Suffice it to say that the principle, which is the underlying principle in those rules, has also been adopted with necessary modifications to fit into the pattern of the present Act in the compensation clause, which is clause 13 of the bill. The principle is the liability to pay compensation. Full stop.